Wish you very happy New Year 2025. My dear friends, we are at the end of 2024. This year is a milestone for the Constitution of India because 75 years of Constitution and the role of Supreme Court has been instrumental in promoting the Constitution, in evolving the Constitution, providing judgments. India being the largest democracy in the world, there are many constitutional judgments which have transformed our democratic values. It is very important we also recollect some of the judgments of 2024 which established the constitutionalism, constitutional values and constitutional morality. My dear friends, the 75 years of Constitution is just not year of celebration but year of continuous evolution of Constitution from 1950 to 2024. The first landmark judgment of 2024 is electoral bond scheme being declared unconstitutional by the 5-judge bench of the Supreme Court. The Supreme Court in Association for Democratic Reforms and others, Union of India, February 15, 2024, held that anonymous electoral bonds are violative of the right to information under Article 19, Clause 1A of the Constitution of India. Accordingly, the scheme has been struck down as unconstitutional. Beyond this, the court considered two key decisions, namely, first, whether the non-disclosure of information on voluntary contribution to political parties according to electoral bond scheme and the amendments to Section 29C of the Representation of the People Act is constitutional or not, and accordingly, it was held unconstitutional because electoral bonds are squarely violative of certain fundamental rights under the Constitution of India. Considering all these facts, the Supreme Court declared electoral bonds as unconstitutional, and moment it is declared as unconstitutional, the electoral bond scheme has been stopped by many political parties. Second important landmark judgment of the 2024 of the Supreme Court is legislative privileges of MP MLAs wherein they are not protected from the bribery. This is the judgment of 7-judge bench of the Supreme Court. In Sita Soren versus Union of India, dated March 4, 2024, the Supreme Court overturned 1998 P.V. Narasimha Rao judgment which held that the members of the Parliament and Legislative Assembly could claim immunity under Article 105(2) and 194(2) of the Constitution for receiving a bribe in contemplation of a vote or speech in the legislature. The court categorically held that the offence of bribery as per the Prevention of Corruption Act is complete moment the illegal gratification is taken, and it is immaterial whether the legislator votes or gives a speech later in the House in terms of the bribe. Accordingly, the offence of bribery is agnostic to the performance of the aggrieved action and is crystallized on the exchange of illegal gratification. It does not matter whether the vote is cast in the aggrieved direction or if the vote is cast at all. The offence of bribery is complete at the point in time when the legislator accepts the bribe. Accordingly, the judgment was provided wherein they held that the legislative privileges of MP and MLAs doesn't protect them from bribery. The third important landmark judgment of the Supreme Court is permissibility of subclassification within scheduled caste for reservation. This is a judgment of the 7-bench judge of the Supreme Court. In the state of Punjab and others versus Devendra Singh and others, dated August 1, 2024, the Supreme Court held that subclassification of SCs, that is scheduled caste, is permissible to grant separate quotas for more backward within the SC categories. The states can identify more backwards among the SC categories and can subclassify them for separate quotas within the quota. The court clarified that while allowing subclassification, the state cannot earmark 100% reservation for a subclass. Also, the state has to justify the subclassification on the basis of empirical data regarding the inadequacy of representation of the subclass. Accordingly, the Supreme Court held it is permitted to subclassify within the classification of SCs. The fourth important landmark judgment of the Supreme Court in 2024 is the minority status of Aligarh Muslim University. It is a 7-judge bench of the Supreme Court which upheld the minority status of the Aligarh Muslim University. In Aligarh Muslim University, through its registrar, Faizan Mustafa versus Naresh Agrawal, dated November 8, 2024, 7-judge bench of the Supreme Court overruled the 1967 S. Aziz Basha versus Union of India to the extent it is held that the institution incorporated by a statute cannot claim to be a minority institution. And of course, the issue of whether Aligarh Muslim University is a minority institution as per Article 30 of the Constitution of India is now left to be decided by the regular bench of the Supreme Court. The key issue of reference to deliberation was, what are the indicia for treating an education institution as a minority education institution? Would an institution be regarded as a minority education institution because it was established by persons belonging to a particular religion or linguistic minority? Or is it being administered by a person belonging to a religion or linguistic minority? And finally, the Supreme Court held that Aligarh Muslim University is a minority institution, and accordingly, all the privileges of minority institution will squarely apply to Aligarh Muslim University. The fifth landmark judgment of the Supreme Court is validity of Section 6A of the Citizenship Amendment Act recognizing Assam Accord. My dear friends, Section 6A of the Citizenship Act 1955, the Supreme Court upheld the constitutional validity of Section 6A of the Citizenship Act 1955. It was held that those migrants who came from Bangladesh to Assam based on a particular cutoff date, their citizenship is upheld to be constitutional. And we have to understand that the Constitution of India functions with the main core as an idea of fraternity. In fact, the judgment paved the way to understand the concept of fraternity. Accordingly, the fraternity has been explained in a detailed length as part of this judgment, wherein the Section 6A of the Assam Accord was held to be constitutional up to the cutoff date. My dear friends, this judgment is a very, very important judgment of the Supreme Court upholding the principles of fraternity along with Section 6A of the Citizenship Amendment Act 1955. The sixth important landmark judgment of the Supreme Court is with respect to bail and arrest. UPA, that is mere delay in trial, not ground to grant bail when grave offences are involved, said the Supreme Court. It was held in Gurvinder Singh versus State of Punjab and others. Bench comprising of the Supreme Court held that merely delay in trial cannot be a ground to grant bail when grave offence under the Unlawful Activities Prevention Act 1967 are involved. The bench also observed that the rule, bail is the rule, jail is an exception, was not applicable to UPA. However, the Supreme Court in later decisions delivered this year disagreed these views, and of course many bails were granted under the UPA and Prevention of Money Laundering Act and other important heinous acts as well. Accordingly, with this perspective, in case of UPA, mere delay in trial is not the ground for granting bail, was the law established by the Supreme Court as part of the UPA Act. The seventh important landmark judgment of the Supreme Court is with respect to the case relating to the Minister of Tamil Nadu, Senthil Balaji. It was held that requirement of expeditious trial must be read into the special statute imposing stringent bail provisions. Accordingly, the Supreme Court, while granting bail to former Tamil Nadu Minister Senthil Balaji, held that higher thresholds for granting bail in stringent penal statutes like PMLA, UPA and NDPS Act cannot be tool to keep an accused incarcerated without trial. Accordingly, the bench granted bail to the former Minister of Tamil Nadu, Senthil Balaji, and he was out on bail and subsequently became minister as well. The eighth landmark judgment of the Supreme Court with respect to bail and arrest is arrest and remand illegal if accused not inform the grounds of arrest. Even filing of the charge sheet won't validate illegal arrest, held the Supreme Court. In case of Prabir Purkesta versus State, the Supreme Court opined that an illegal arrest and remand order cannot be validated merely on the ground that the charge sheet has been filed. It was held clearly, I quote the exact quote of the judgment, mere fact that a charge sheet has been filed in the matter, could not validate the illegality and unconstitutionality committed at the time of arresting the accused, and the grant of initial police custody remand to the accused. It was held in the Supreme Court judgment. The judgment also held that the dictum in Pankaj Bansal that the grounds of arrest must be given in writing when a person is arrested under the PMLA is applicable to UPA as well. The ninth landmark judgment of the Supreme Court is advocates are not liable under the Consumer Protection Act for deficiency of services, held the Supreme Court. It was held in Bar of India lawyers through its president Jasbir Singh Malik versus D.K. Gandhi, PS, National Institute of Communicable Diseases, 2024, wherein the Supreme Court held that the advocates are not liable under the Consumer Protection Act that is reenacted in 2019 for deficiency of services. The court held that professionals have to be treated differently from other persons carrying on business and trade, and accordingly, advocates are not liable under the Consumer Protection Act. 10th landmark judgment of the Supreme Court is with respect to climate change. For the first time, the Supreme Court has voiced its concerns on the climate change. The bench, through its judgment on March 21, 2024, held and recognized the right to be free from adverse effects of climate change as a distinct legal right. The court said that Article 14, equality before law and equal protection of laws, and Article 21, right to life and personal liberty of the Indian Constitution, are important sources of this right. Accordingly, India's apex court, that the Supreme Court is one of the first courts in the world to come out with this kind of judgment. It's one of the landmark judgment because in these current times, we know about the effects of climate change, and it's very important how the Constitution is going to evolve to the requirements of the climate change. At the end of the day, it is the lawyers who take the Constitution to the doorstep of the citizens. In the 75 years of the Constitution, lawyers must understand the words of brain garners elements of legal style. Wherein Charles Allen Wright says, I quote the exact words of the court. The only tool of the lawyer is words. The great goal in writing is clarity. Persuasion is important, but we cannot persuade if we are not clear in saying what we want done and why ought to be done. The rules of usage developed over the centuries are intended to produce clarity. Observance of them leads professional polish to the product, and this in turn inspires confidence that the writer or speaker is equally professional and equally competent on matters of substance. Of course, Lord Denning words are telling that to succeed in the profession of the law, you must seek to cultivate command of language. Words are the lawyer's tools of trade. The reason why words are important is because words are the vehicles of thought. Thanks for being my supporter and supporter of the Constitution of India. My commitment to you in this year 2025 is to bring the Constitution near to you. Happy New Year once again.